Good morning. My name is Jill Chilcote. I'm a partner here with the law firm of Lincoln, Gustafson & Serkos, and welcome to the first presentation in our series of seminars for small businesses and employers. Our firm has been in business since 1987. We've got offices in California, Nevada, and Arizona, and we provide a multitude of legal services to clients, including business formation, contracts, consulting, risk management assistance, and of course, representation for legal disputes involving employment issues, business issues, and a multitude of other civil litigation issues. And we're here today also with Back Office Support Solutions, BOSS, who is a premier accounting firm here in San Diego, who provides services also nationwide. And BOSS provides bookkeeping, accounting, human resources, some recruiting, a multitude of services that businesses may need. And our goal here today is to provide information and help to businesses and employers who are not necessarily aware of changes and amendments and all the multitude of laws that they need to keep up with in the California business climate. We will be going over a bunch of different amendments and recent changes to the law and hopefully provide information to help everyone avoid trouble in the future. And here I am here with Rico Correa, and Rico is going to first give us a little introduction on the business climate here in California, and then we'll move right into our topic.
Well, as most of you know, the climate here can be somewhat confusing, can be somewhat complex. As we deal with small businesses on a regular basis, what we're hearing is laws are changing, amendments are changing, our requirements are changing. What requirements do we have in terms of compliance? What do we need to do? What are our potential liabilities? Those are all questions that we're here, and hopefully we're going to be able to answer with some of the recent laws and some of the recent changes. And really one of the things that we really want to get to is, what are the laws? What do they mean? What are the potential liabilities, and what is it that we can do as small businesses and as employers that will eliminate or at least decrease the chance of non-compliance or potential liability? So that's really what our goal is today. And thank you for coming. We really appreciate it.
Yep. Now, before we get started, I of course have to mention that the information we're providing is general information, and it shouldn't be relied upon for any specific situation that would require a consultation with a qualified professional. And just to give you an overview of the topics that we'll be going over today, we've got a presentation here. We're going to first be talking about the new California sick leave law, California paid sick leave law. Also, the joint employer liability that is resulting from an amendment, recent amendment, and involves acts of independent contractors for which hiring businesses can be liable. We'll also talk a little bit about wage statement violations, and that's the Private Attorney General Act, PAGA, that deals with wage statements, and some amendments that are causing effects that weren't necessarily envisioned when those amendments went into place. And if we have time, we'll also talk a little bit about the California Fair Employment and Housing Act and a recent amendment to the issues of disability and religious accommodations requests, as well as the California whistleblower statute. There's been a recent amendment that broadens that statute. So, jumping right in, we will first start with the California paid sick leave law. And this is an amendment to the Healthy Workplaces and Healthy Families Act of 2014. And so as of July 15th of 2015, this year, any business that has at least one employee has to provide paid sick leave to that employee as long as that employee has worked at least 30 days within a year. This includes temporary, seasonal, part-time, all kinds of employees who've worked the requisite number of days within a year. And it kicks in once an employee has worked at least 90 days. So there is a probationary period, so you don't just get new hirees that take the paid sick leave and then leave your business. So there is that initial period. Now, the law says that paid sick leave can be taken for illness, treatment of a health condition, even care for other family members with health conditions, and also issues such as employees who've been victims of domestic violence, sexual assault, or stalking. So sick leave covers all of that. Paid sick leave is different, however, from accrued vacation, which is a vested benefit, and sick leave does not have to be paid out when an employee quits or is terminated. This new law provides about 3 different ways that employees can provide and accrue the sick leave, and Rico will be talking about those different methods. There's a lump sum method and 2 different accrual methods, so Rico will talk about that in just a moment. And the law also says that employers can cap employees' usage of the paid sick leave at 3 days or 24 hours in 1 year, regardless of how many hours the employees may have accrued of the sick leave. So employers can set a cap on, only letting employees take 3 days of sick leave if, they really need those employees there at work. This new law requires that employers post the new sick leave law and rights for employees at their place of business. And if you get any new employees, you also have to give written notice of the new sick leave law to those new employees. You also need to make sure that wage statements are listing the amount of sick leave that's been accrued and used. Employers must keep records of all the accrual of sick leave and the use of sick leave for at least 3 years. And the law prevents employers from retaliating against employees for taking their paid sick leave. Now, retaliation, that means no employer can do what's called an adverse employment action against an employee. And some of you may already have heard this term, adverse employment actions. What does that mean? It's not just firing or demotion. It can be things as subtle as changing a job schedule, changing hours, changing whoever the supervisor is, things like that. It can also be things outside of work, making threats or taking other actions against employees. Anything that's going to discourage an employee from exercising their rights can be an adverse employment action. And so you want to make sure that your managers and your supervisors are aware of these issues, because any adverse employment action that's taken within 30 days of a protected activity is presumed to be retaliation. And the employer is then going to have to spend a lot of time and money proving that they had a legitimate business reason for taking whatever action they took.
That's a really important point, because many times there's subtleties that go on in the workplace that we don't necessarily see, or business owners don't necessarily see as having an adverse impact, without kind of thinking through that process. So it's a very, very good point, very important point.
Yes, and it can be very expensive to have to defend those retaliation claims if employees make them. And it's very easy for employees to make those claims. They just have to march on down to the DFEH or the EEOC and fill out a piece of paper, and boom, there you are. You're going to need some help probably to oppose that, and hope that a lawsuit doesn't result. So you really want to watch out for those. Now, so the next thing we're going to talk about is what can happen if you don't comply. There are all kinds of different penalties that can result from failure to follow this new California paid sick leave law. The first thing that can happen is you can be forced to pay back pay to employees for any sick leave that they took where they weren't paid and they should have been paid. The second thing is you might have to pay employees for any sick time that was illegally withheld that they should have gotten and you didn't let them go on sick leave. You can have to pay them for sick days withheld. And these types of actions are prosecuted by the Labor Commissioner and the Attorney General's office, who will also impose penalties. There are a ton of administrative penalties that can be imposed, which can be $250 or 3 times the wages for the sick leave time that was not given, up to a cap of $4,000, because it's either $250 or 3 times the wages, whichever is greater. So that can be all the way up to $4,000. Plus, there are also additional penalties for failing to put the notice up at the business, notifying employees of their rights. And if you have a continuing violation, you can be fined $50 a day all the way up to $4,000, a cap of $4,000 for continuing violations. So those penalties can really add up. That's in addition to anything that you might have to pay back to an employee. You can also be on the hook for penalties with the Private Attorney General's Act, which we'll talk about in a second, and that's with regard to the wage statements, not having that information on the wage statements. We'll have a whole section on that in a moment. And then lastly, you can be liable for attorney's fees, costs, and interests. And these claims, again, can be very expensive. So what can employers do, Rico, to help avoid liability?
Well, I think the first thing is awareness. Being aware of what it is that as an employer you're responsible for. The second thing is going back and making sure that you check, that you know what you have, that your employees are very clear about what it is that you have. We're going to talk about some of the things that we can do, but before I do that, I just want to add a caveat, and that is so many companies that we deal with, so many employers that we deal with will have an employee handbook, will have policies and procedures. The problem has been historically not keeping up and not changing those appropriately when they need to be changed. One particular instance where that can be very harmful when it comes to the new Sick Leave Act is when employees have accrued time. If you have accrued sick time, there's normally a formula. That formula is 1 hour for every 30 hours or 1 hour for every 24 hours that an employee works. But now with the new law, there's a potential cap. So the law specifies on one hand that what we can do is cap that as an employer at 24 hours, and yet our policies don't state that, and therefore they'll keep on accruing. So it's something that's very, very important that we go back and we make sure that your handbook, your policies, your procedures comply with and are changed and modified accordingly. Current time off is reviewed. First and foremost, review it. Take a look at your current policies. Take a look at your current handbook. Take a look at what your employees think is the regulation or the policy. Second is understanding which way that we can calculate it. Historically, over the recent years, employers have chosen what's called a PTO bucket, which is usually a combination of personal time off, sick time, and vacation time. The problem with that is that if the new law specifies a certain amount of sick time, you really have to qualify it as sick time. Secondly, again, it may in fact accrue as a PTO at far greater hours than what the law really specifies you need. So you actually could have a policy, an internal policy, that allows employees to accumulate 8 days or 10 days of sick time, or 8 or 10 days of PTO time, which actually have some dramatic ramifications, especially if and when an employee leaves. A company will have to pay out that time, whereas if it's specified as sick time, you wouldn't have to pay it out. Okay, so that's one thing. The other is, what method are you going to use? Is a company going to use the accrual method, which says 1 hour of paid sick time for every 30 hours that an employee works? It's very important to understand that it does not matter as to whether it's a full-time employee or a part-time employee. Every employee that works over 30 hours will gain at least 1 hour of accrued accrued sick time, I'm sorry. What a lot of companies are doing is what they're calling the lump sum method. And that is that we front load that. In the beginning of the year, we actually give all employees 24 hours of sick time. You put it into the bank, into the employee bank, you specify it as that, and then the employee works off of that regardless of how many hours they happen to accrue. The second method is the accrual method. The accrual method is a little bit more complex, and what you want to do is you want to create a formula that says the average employee works X amount of hours per year, and what will be the formula that we would use to accrue that 24 hours over the course of a year. Much more complex, much more technical. The easiest thing for most employers to do, and the thing that we suggest the most, is front load it. give them 24 hours right in the beginning of the process, and then let them pare that down. An important other aspect is that if an employee leaves the company, if their sick time is in the bucket of PTO, the employer will have to pay that time. If it's in a separate bucket called sick leave, they will not have to do that. So the first thing that we say is for employers and small businesses to check your regulations, check your policies, know what it is that you have. The second is to decide very early on which of the methods you're going to use. And again, our recommendation is that you use the upfront, front-loaded method. And the third is to apply those policies consistently. I'm going to talk a little bit more later on about the laws and the amendments and what you called a little earlier adverse impact, and the kinds of subtleties which can create that. And we're going to talk about that a little later on down the road, but that's very important in terms of the California sick leave law.
Okay. So our next topic this morning are the recent amendments to the California Labor Code section 2810.3, which deals with business liability for the acts of an independent contractor. This amendment became effective January 1st of this year. And before the amendment, businesses typically were not liable for the acts of their independent contractors. But now they can be liable for certain circumstances where independent contractors fail to pay for their employees' wages, fail to procure workers' compensation insurance, or fail to comply with Cal OSHA requirements. So this amendment only applies to businesses that have at least 25 employees, as opposed to the last one we went over, it was any business with 1 employee. This one applies to businesses with at least 25 employees, and those businesses are typically referred to as the client employer when talking about this issue. And it applies to independent contractors who have at least 7 workers who are working in the usual course of the client employer's business and are working either at the client employer's work site, their place of business, or on a job site.
Let me ask a question here, and maybe I'm getting ahead of us, but let's talk for just a second about usual course of business. What does that mean from not only a legal standpoint, but what does it mean from a regulatory and human resource standpoint?
Well, it's a little bit tricky to tell you from a legal standpoint, and that's because the amendment is so new, we don't have a lot of case law that interprets what usual course of business means. But we did have one federal case come down in September called Stubbs versus Covenant Security Systems. And the Stubbs case involved an oil refinery that had hired a security company to come in and provide security. And so the security company failed to pay its employees. The employees sued in a class action, and the employees also sought to name the oil refinery as a defendant. Well, the oil refinery said, come on, these are your employees, to the security company, and the security company should be liable. We don't provide security. That's not our usual course of business. And so this lawsuit should be dropped against us. And they challenged it. They filed a motion to dismiss in court. Well, the court interpreted the statute broadly. Courts typically often want to protect employees, and that's what the federal court did here. They allowed the lawsuit to proceed against the oil refinery, saying that, actually providing security is something that is in the usual course of business for an oil refinery. So they went ahead and allowed that to go forward. And it may be that courts would interpret things broadly for the public policy of supporting employees out there who need to be paid and need to be protected on their job sites with Cal OSHA requirements and things like that, and need to make sure that there's workers' compensation insurance in place.
That's a very important point, because many companies will hire that third-party employer just for the sole purpose of relieving themselves of the potential of liability. So this is very key, because what it does is it tells employers, just because you hire a third-party company doesn't necessarily mean that you're going to not incur or potentially incur some liability. That's why I think it's very important to make sure, again, that you understand the relationship and that the employer or the business understands the relationship that they're going to have and whether it may or may not meet that test of usual course of business.
Yeah, that's right. And also, so this law doesn't only apply to typical independent contractors like this security company type situation that we just described. It can be this staffing agency type situation. So you hire a staffing agency to get some people in, or you need workers for a big project and go somewhere like Labor Finders or Labor Ready, one of those things. So those are the types of situations where this could occur, as well as with other independent contractors. So, Rico, what can we do to avoid liability here with these independent contractors?
Sure. And again, it's very important. First of all, confirm with the independent contractor. Make sure that you're very, very clear about the relationship. What kind of relationship are you going to have? Where do potential liabilities stand? Where do potential responsibilities stand as we go, as you go through that relationship? So make sure that that the independent contractor has proper workers' compensation insurance, has the proper regulation, that they have in fact done the proper eligibility and verification requirements when it comes to whether that employee is actually eligible to work. Validate that all your employees that you hire, it's going to be that they are eligible and validated as employees. Require that the independent contractor carry employment practice insurance, just in case. Again, you may or may not have the interpretation of whether there's independent liability or not, but I think that the key is it's probably going to still be attorney fees and depositions and all kinds of things that are going to potentially cost you. So to make sure that they have the insurance and name your business as an additional insured. That's always one way to be able to kind of hedge that if you are included in a class action or some kind of a litigatory action, that they are insured and they're actually insuring you as well.
Yeah, and on that point, you might want to be even extra careful. A lot of companies will provide you with just a certificate of insurance from their broker. But you may actually want to ask for a copy of the endorsement that extends the coverage to your business as an additional insured if you're going to go ahead and require that they name your business as an additional insured on their employment practices liability policy.
And then finally, require indemnification. Listen, if there is that opportunity or if there is that chance, we want to be indemnified. We want to make sure that you, the employment company or the independent contractor, are taking on all of the responsibility on this. That's something, by the way, that doesn't usually get talked about in the front end of this process because no one kind of expects it to happen. It only comes up most times at the back end of the process after something has happened, and then we really have discussion over whose responsibility it is.
Right, and it may be very important to get an expert to take a look at the contracts that you actually have and look at those indemnity provisions. Indemnity provisions and contracts are kind of make some people's eyes glaze over. You may want to have your attorney or a company like our firm or somebody who is an expert in these types of contracts take a look at that language and make sure that the indemnity provisions are running the correct way. Now, sometimes if you're getting into a labor ready situation or a staffing agency and so forth, they're going to have an indemnity provision in their contract that makes the hiring business liable for any accidents or problems that could happen while that employer is supervising these hired employees. But you can have a second indemnity provision in there that makes the lending employer liable for these wages, workers' compensation insurance, and compliance with the OSHA requirements. Okay, so because this is the law, you might want to have that separate indemnity provision to protect you on the other side. The indemnities can go both ways in the contracts. It can be complicated. You might want to have a lawyer look at it for you, but that's something to definitely be aware of and make sure that you're doing in order to avoid this problem.
And the key most likely is let's talk about, let's discuss, let's agree on those issues in the front end of the process. and not when all of a sudden we have to scramble to find out whose fault it is.
Okay, so we're going to move on to our third topic of the morning, which are wage statement violations under the Private Attorney General's Act. So, California, under Labor Code Section 226, lists 9 different items that have to be on an employee's wage statement. So it's things like hours worked, gross wages, any deductions, net wages, time periods that are the pay period, employee identification information, and employer identification information, as well as hourly rates and some of these other things on here. So there's 9 different things. It's highly technical, okay? And failure to provide any of these items on a wage statement subjects employers to penalties. And also, in addition to penalties, employees can sue under the Private Attorney General Act to recover those penalties so that the Attorney General doesn't have to go ahead and do it for them. And so with the 2013 amendments, in the past, before the 2013 amendments, in order for an employee to go ahead and sue under the Attorney General's Act, they had to show that they had a resulting injury from the failure of their wage statement to be correct with all 9 of those items. But with the 2013 amendment, now the injury is presumed. So it's automatic injury. It makes it very, very easy for employees and their attorneys especially, who might be a little opportunistic, want to get a quick payout, and can find some technical violations, and they can automatically get those penalties, including attorney's fees, interest, and costs for any little technical violation on a wage statement.
You know, it's interesting too, because actually when you look at this, the burden shifts. You know, the burden will shift from an employee having to show somehow that they were damaged to now a presumption that says, well, you are already damaged. One of the things that's interesting, we're going to talk about this a little later on when we talk about employer actions, is so many times employers don't even know what's on their statement. They haven't even looked. They don't want to make sure, they haven't made sure that the 9, requirements are on there. It's very simple. When you get your paycheck, you take a look at it. It says this, yes. If it doesn't, then change it. And that may be a simple matter if you have a third-party payroll company. You just get together with your payroll company. You make sure that they're aware of the law, they're aware of the amendments and changes, and that you make sure that when they do payroll, all of those elements are included. It's just very, very difficult, and I say it all the time, it's easy to prove that you did something, very difficult to prove that you didn't.
Right, and we used to see these claims tacked on to wage and hour class actions where employees were trying to get paid for overtime that they should have been paid or meal and rest periods that they missed, and then we would see the attorneys tack on these little wage statement violations because they could get penalties as part of a big package in a class action. But now, because they don't have to show injury, it makes it very attractive to just file a standalone lawsuit on these little technical violations. You could have a minor violation in the name of the employer on the wage statement, the person who's supposed to be paying, that's one of the 9 items. And if you have that technical violation, presume damages. So we can go ahead and sue the employer, get all the penalties under the law, and get attorney's fees and costs. It makes it very expensive for employers, and you end up possibly paying a bunch of money to settle those lawsuits.
So as we talked a little earlier, what is it that we can do as an employer to prevent those kinds of issues? Well, obviously you carefully scrutinize the wage and hour statements, you take a look, you make sure that it has all of the required information on it, and then if you have a third party or you have a payroll company, that you coordinate with those companies to make sure that they know the law and that they know what it is that they're required to do as well. Kind of a simple solution that could have some dire consequences if you don't do it.
Yeah, be on the lookout for people out there that are looking very carefully just to find little technicalities and going after businesses for a quick and easy payout. That's something that's happening. Okay, so moving on to our fourth topic. There are new protections pursuant to the California Fair Employment and Housing Act with relation to requests by employees for religious and disability accommodations. So FEHA protects employees from illegal discrimination and retaliation for engaging in protected activities. And so employers can be liable for retaliation for discrimination. And in the past, it was unclear as to whether or not employees were protected for merely asking for an accommodation, whether or not the accommodation was actually given. And it came up in a lawsuit called Rope versus Autoclore Systems. And the court in that case, because the statute wasn't clear, they made a ruling that the mere act of requesting an accommodation was not protected. This amendment changes that. It makes the act of requesting an accommodation a protected activity. Employers cannot retaliate in response to an employee just asking for a religious accommodation or a disability accommodation, even if the employer does not grant the accommodation. Asking itself is a protected activity. So what can employers do, Rico, to avoid that?
First of all, be as flexible as possible. And I want to go back to something that you said a little earlier, and that is retaliation. And what is it? In my experience, many times the employer, the manager, the supervisor certainly does not see that particular action as retaliation. You know, you asked for an accommodation, I turned it down. But now I start to treat you a little differently. I start to talk to you a little differently. I change your shift. You don't get as good of an evaluation as you thought you were going to get. Little things that when many times we talk directly to managers and supervisors, they go, well, you know, that's well within my right, and I think that was fine. One of the things that's very important is to understand that as a manager or as a supervisor, the person who is or is not going to interpret your actions as retaliatory is not going to be you. It's going to be someone else, the reasonable person. Okay, and I say it all the time, we haven't met the reasonable person yet. It's always someone out there who's the unknown. So it's very, very important to understand how might someone who is not me take the action or behavior that I'm doing. How might someone who's not me? And if managers and employers can ask that question more often, I think that we will keep them out of harm's way a lot more than the way that it is right now. Train your managers and supervisors. Make sure all your managers and supervisors are trained in not only what the law is, not only what the amendments are, but what they mean and how they are supposed to act and behave and what their attitudes are supposed to be. Many times, businesses sometimes can be penny wise and pound foolish. They kind of sacrifice the training aspect until they need it, as opposed to being preventative, and that's a key. Avoid engaging in any behavior that can be seen as retaliatory. Well, the question always is, how might someone who's not me take that? And that's one of the ways to be able to get an answer to this question, as opposed to just kind of looking at it internally. Be cautious of any adverse employment action following an accommodation. Okay? So you got to be very, very careful when an employee asks for an accommodation. Be very cautious about what could or may come next. Okay? And lastly, when in doubt, and this is always something that we say, when in doubt, consult the professionals. Consult people who do this all the time, people who know it all the time. And it makes things a lot easier when we talk to someone like you or you talk to someone at Boss and we go, listen, this could be seen as retaliatory. This could have an adverse impact. And asking those questions ahead of time, or at least asking them as you're going through that process, is going to save you a lot of time, a lot of money, and probably some good employees.
Yeah, and like I said earlier, it's so easy for employees to just go down to the office, they fill out a piece of paper saying, I think I was retaliated against because my employer did this or that, or I think I was discriminated against, and that triggers this whole system where you now as an employer have to respond to these allegations. They get investigated by the government, FEHA, either through the DFEH, the Department of Fair Employment and Housing for California, or the EEOC, Equal Employment Opportunity Commission for on the federal side. When an employee goes down and fills out paper at one of those places, it automatically triggers a simultaneous filing with the other entity. And so you start getting investigated, you have to respond to those allegations, which can be very expensive, time-consuming, and difficult. And after that process, the entity will decide whether it's going to issue a right to sue letter, or the employee can ask for a right to sue letter, and at that point they can go ahead and file a lawsuit against you. Now, you want to avoid that whole process if you can. If you do get a DFEH or an EEOC complaint, it may be in your best interest to hire a law firm to take a look at it and help you prepare that response, because whatever response you give could be used in a later lawsuit if the employee gets a right to sue letter. Our firm's had some great results in opposing those governmental entity investigations on the front end before a lawsuit and preventing it from moving on into a lawsuit. So it can be very helpful if you go ahead and get the help as soon as you get those letters, rather than waiting to be sued after the employee gets a right to sue letter. They can just ask for it. They don't have to prove anything to the governmental agency. They can just ask for the right to sue letter and then move on. So if you can do the best you can on the front end to shut it down, that's the way you want to do it.
Well, the key component to this is right here. Training your managers and supervisors. Train them and have them understand that they are agents. What they do, the company did. What they know, the company knows. What they said, the company said. What they failed to say, the company failed to say. Many times managers and supervisors don't understand that that's the position that they are held to and the standard. And so organizations end up with having to defend themselves because a supervisor, a manager didn't know what's expected of them, took the wrong action, said the wrong thing, behaved in the wrong way, and now because what they did, the company did, they find themselves behind the eight ball.
And so our final topic this morning is going to be the recent amendment to California whistleblower protection, which is extended to internal reporting. So this is under Labor Code Section 1102.5. It protects whistleblowing. That's when an employee suspects that there's been some type of violation of a law or a regulation by their employer or somebody at the business, and they report it to a governmental agency that is tasked with enforcing those types of violations or investigating those types of violations. And so California used to protect, or they still protect, but before the amendment, the protection only extended to the reporting of those suspected violations to the governmental agencies. Well, now, since the amendment, employees are also protected for reporting those suspected violations to somebody within their own organization who is tasked with investigating, discovering, and or remedying that type of a violation. So it broadens the protection of whistleblower protection under California law, and for retaliating against a whistleblower, you can again get in trouble with potential for penalties, civil damages, having to pay attorney's fees and interest, and all kinds of very expensive consequences.
This is a key change, because normally when we looked at whistleblowers, we thought of an individual going outside of the organization, going to a third party or a third party organization or an agency, and then giving information. What this is really saying is, if I come to you as my manager and say, I'm really concerned about this going on, or I watched this and observed this and I really have some concerns about the ethics of it or the legality of it, you now as an organization have an affirmative responsibility to do two things. One is to do something about it, but just as importantly, to make sure that there is no adversity or no retaliation that happens on the part of that individual because they did come forward. And I think that's a key determination now that companies are going to have to make and understand.
Yeah, and it doesn't even have to be an actual violation. If an employee just suspects it's a violation, but maybe it's not, and they tell somebody that it needs to be investigated or they think something's wrong, even if it's not a real violation, still that their act of going ahead and trying to do something about it is protected. It doesn't have to be an actual violation. So that sums up our 5 different topics this morning with the recent amendments that we were able to present in the short time frame that we have. I hope that this was an informative seminar and will help employers, small businesses to hopefully avoid pitfalls and getting into trouble down the line. And I hope that you'll be interested in joining us for our other presentations in this series, which we'll be planning to do throughout the year and next year. And thank you very much for joining us.
There's much more to come. Thank you very much. Thank you for joining us. If you have any questions, any comments, you can certainly contact us. You can contact us on the sites. You can contact us by email or text. We appreciate it. Come back and join us again. Thanks.
Thank you.